The evidence seems to indicate that you're watching Dolly Vision.
Topping up, Dolly Vision's dreaming real. Two crime scene blast feel so unreal. YouTube madness like share, subscribe. Jack's on fire, burning the world's fire. Where's the baby missing shadows crawl? People whisper footsteps down the hall. Fingerprints of the dead, cold as stone. He's got the scoop, there's the rock down known. Dolly Vision headlines, King the Beat. Truth unravels, crackling through the heat. Lost soul shouting, echoes in the night. Mock the truth while live on their light. Topping up, Dolly Vision's dreaming real. True crime scene blast feel so unreal. YouTube madness like share, subscribe. Jack's on fire, burning the world's fire. Where's the baby missing shadows crawl? People whisper footsteps down the hall. Fingerprints of the dead, cold as stone. He's got the scoop, there's the route down known. Dolly Vision headlines, King the Beat. Truth unravels, crackling through the heat. Lost soul shouting, echoes in the night. Mock the truth while live on their light.
Good morning, my beautiful people. It is good to see you guys. Today is Karen Rea motion hearings day 2. It starts in about 10 minutes. They enter the courtroom, and we're going to be here to watch it with you guys live. But nothing's changed. Make sure you leave your DNA on the like button just in case Karen Rea backs over your ass at 24 miles an hour in reverse and leaves you for dead. Okay, just it could happen. Trust me, it could happen. This woman's still out drinking and partying, so make sure you leave your DNA. And if you're brand new, sub up, ring a bell for notifications, and feel free to share my ugly face on any social media platform, long as it's not Pornhub. Okay, so who's been watching the documentary series on the ID channel about Karen Rea? So I caught the last 2 episodes last night because I fell asleep during the one. I hate to say it bored my ass to sleep, but I got to catch up last night after the stream with you guys of, just destroying that wannabe YouTube creator. So then I sat around and watched a little bit of the Karen Rea stuff. And then I was like, okay, well, I'm going to be here to cover it. Right. So I'm going to be here for a little bit this morning, and then maybe PJ will take over a little later, depending on how long this motion hearing runs today. And hopefully Hank the Tank goes in kicking some ass. She looks guilty. I mean, listen, I think the documentary makes her look terrible, and it shows that she conspired with Turtleboy to harass the witnesses in these cases. In the show last night, she said, well, they shouldn't be witnesses. They should be suspects. But that's not you to make that decision, right? But they are witnesses, and you are harassing them and allegedly paying to have Turtleboy harass these people. I've been watching it, Dolly. Cool, Kimberly. I hope you're enjoying it. I mean, it's a good documentary. It ain't nothing new that we haven't seen and we don't know. It's a little dated because now we know that Hoslong to die in the cold didn't happen at 2:47 a.m. Like, in the documentary, they're saying they're still trying to push that Hoslong to die in the cold. But, we've had experts from Celebrate come out and say, hey, and these are the people that designed the software, say, the search was made at past 6:30 in the morning. Brian brought the knife used off Amazon. He was at the victim's house. What do you mean, Carolina, Nana? That he bought the knife from their house? I mean, I know that. Oh, that the knife was bought and the sheath was bought on Amazon? We knew that. They just never found the murder weapon. Okay. Yeah, BK is done. Yeah, I mean, we knew he got the knife sheath off Amazon. We've been known that. Just the thing is, they never found the murder weapon. Now, if he ordered it from their house, that'd be a little strange and a whole lot of change right there. So nothing new. Who is TB? TB is Turtle Boy. Okay, he's a wannabe blogger, which is, I don't even know why they call him that, because there's nothing else to call him. He was a school teacher till he sexually harassed this girl, and they were getting ready to fire him, so he just went ahead and moved on, allegedly. And he started writing this little publication that nobody reads because it's full of pop-ups. Like everything's a commercial. So he's basically a dude that made t-shirts of Karen Rea to sell and not give her any of the money. Just a basic grifter, no more than a con. He gets paid to harass people, and he has a pack of women that follow him, right? And that's basically what he does. I mean, in a nutshell. TH is toilet bowl. Who is TH? I don't know who TH is. Good morning, Dolly. I'm so glad to see you this morning. First day of spring. Yeah, I hope the weather, it's been a little cold here, warm, cold, warm. I'm hoping it just goes to summertime weather. So, Turtle Boy is definitely not a writer. Okay, we ain't going to give him that type of credit here. He says he's a world award-winning journalist. That I like to see what award he won. Idiot of the Year, maybe. So he's just a con artist, basically. He's just a damn con. No more than that. Turtle Boy is a slap-ass joke. He's worse than T-Rev, okay? Hello, Coffee, my old friends. Good to see you. Yeah, he's definitely ain't no writer. He's just a dude that treats women like shit. That's who he is in a nutshell. And he got his own legal problems. Yeah, at least he has his teeth. That is true. He has teeth, unlike Turtle Boy. Okay, I mean, unlike T-Rev, he still has. Turtle Boy has, at least he has his teeth for now, until somebody catches him in an alley. So, all right, here we go. Let's pull the stream up. Court TV is getting ready to start. Share. Add the screen. Blow this up. Let's go here with it. All right, let's go here. I wonder why my chat's not working like it's supposed to. Dolly TV chat box. Like usually my chat's running on the screen, but for some reason it's not doing that today. I'm not going to write. You still laughing from last night? I don't think she's going to walk, but there's, a lot of her supporters do. I was just watching some of her supporters just a few minutes ago, and they're basically over there, saying everybody's corrupt and they're going to win. And, why do I hear this coming from two places? All right, hold on, guys. We got something going on, some technical issues here. All right, let me do this. Okay, let's mute that for a minute. Why do I still hear it after I mute it? All right. So now I got everything working. I was having some minor difficulties there. Oh, the whole T-Rev thing. Yeah, he does need some help. I did. It's just there's a lot of background noise because they haven't started court yet. They're supposed to be in there at 9, but I think they've been starting a little late. Okay. So, but once everything gets going, we'll be here for it. This is just a motion hearing. The trial don't start to April Fools. They start selecting a jury. And I heard they got 275 people a day for the first week to pick jury. Okay. So with that many people, they're going to be able to pick a jury. And honestly, I think they should have moved it out of Dedham so it could be a fair trial, right? I think, all these people that support Karen Rea holding signs and screaming out in front of the courthouse and things like that, I think it swayed the jury because they can hear them screaming outside. I just honestly think they should have moved it. Regardless of everything, I love her lawyer, Alan Jackson. He is a good trial lawyer to watch. I don't know. Hank the Tank has been destroying him. And Hank the Tank was Whitey Bulger's lawyer, his defense lawyer, but now he's a prosecutor. He's the special prosecutor, Hank Brennan, and he is just killing it. He's a million times better than the last prosecutor. And you got to remember, the last prosecutor had the majority of the people, I think everybody but 3 people hung the jury, and the rest of the people were guilty, saying she was guilty. So I think Hank the Tank is going to take it. And we do know statistically 85% of the people that are retried are convicted. Okay. So she has an 85% chance she's going to be convicted. And I'm pretty positive, if you ask me, Dolly, do you think she's going to be convicted? I would go, yes. I mean, the evidence points to her. A lot of the stuff that they used in the first trial, they won't be able to use in the second trial because they've already debunked it. The house long to die in the cold. They got experts saying from Celebrite, the people that made the extraction software, that the search was done at 6 a.m. So there goes that conspiracy. They got Chloe, which are the dog bites. So they're going to mold Chloe's teeth and show that they don't match, that the wounds are consistent with the taillight of the car. You got the fact that the experts from ARCA were paid by Alan Jackson. Dolly, JLR has all the new evidence and maps. Okay. All right. I'm sure it's online. I'm sure that's where he found it. So I can find it. I don't know if I can really like sit through a JLR video to try to get the information, but I can go online and get it. It's not a big deal. But I've been known that anyway. That's not nothing new. It just came out in court documents. We've been known he ordered the knife sheath from Amazon. So nothing new to me. And plus, I'll be there in Idaho when that goes down. Yeah, we're not really talking about Brian right now. Good point, PJ. We're on the Karen Rea train this morning. Okay. We may get to Brian Kohlberger tonight. So, but thank you for trying to share the information with me, you know. But here's the ceiling fan. Same old dingy ass ceiling fan. Hashtag free the ceiling fan. Yes, the trial should have been moved, but Hank the Tank is the man. Yes. I think he got this. You know, that's just my opinion. You know, I went into some of her supporters' room today and asked them, I said, if she goes to prison, are you guys going to cry? Asked them for a friend. And, you know, of course, I got blocked. All right. Like, you can't have an opinion other than Karen Rea is innocent or they block you. So if you say anything that insinuates, you can't have an opinion with those people, right? Your opinion don't matter. All that matters to them is she's innocent. And if you say, hey, Hank the Tank's going to crush it today, blocked. Karen Rea may go to prison. Are y'all going to accept the fact if she goes to prison? Blocked. So you can't say anything about Karen Rea being guilty. News Nation was reporting the knife on Amazon. Absolutely. I'm sure they were. I'm sure JLR wasn't the first person to get the court filings, right? So we've been known about the knife sheath. That's no news. We knew he got it on Amazon. The fact is this, the 911 call was strange, and Dylan and Bethany's behavior was strange. But like I said, we're talking Karen Rea today. I order everything from Amazon. Okay. I order so much stuff from Amazon. I know at least once a day I'm ordering something from Amazon. But then again, you got to remember, I do all them t-shirt printing. I got to get my supplies. So I order a ton of stuff off of Amazon. Drunk Turkey reported it last night. Yeah. You know, I was busy roasting people last night. We were on a good old roast. So if you haven't seen the roast yet this morning, go check out my live stream from last night. PJ is awake now, and she'll probably take over in a little while for me, right? Because I've been going and going and going like the Energizer Bunny. Yeah, they're just saying where the story came from. LOL, Dolly. I got a replay. I can't wait. Karen Rea looks like she can. Oh, I ain't even gonna read the rest of that. Jim says, "Poor T-Rev. Dolly was roast fire last night." Yes, you know, listen, that was easy work. Some people are just easy to laugh at. You had me laughing so hard last night, says Buck Cherry. Sometimes I give y'all some good stuff. I don't get to do that much up here because, you know, I try to stick to true crime. But, my roast or, no joke the blood from you. But I don't get to do it much. And you know, I had to ask PJ. I was like, can I joke the blood from this guy? And she was like, do you want to give him that attention? And I was like, he needs a hug. I had to get down on my knees to hug him. I was like, but let's give him a little attention. His channel has fell in the cracks of the bottom of nothing into the abyss. So why don't we just, you know, give him a little attention? Like he's like a little baby. Let's, you know, give him a little bro hug. So, but look, when you ask for Dolly's attention, you'll get it, but it's not the attention you want. Okay. It's not the attention you want. So I made easy work of that. I call that easy money. Okay. Easy money. Your poor knees, right? You hugged the F out of him. Yeah, right, Jennifer B. He got my attention, right? He got my attention. I don't know if that's really what he wanted because he took the video down before I woke up. But he got it. He got it last night. At PJ, missed you this morning. PJ has not been feeling good. So she was feeling really bad last night. And that's why I ended like I did, because she just, you know, she woke up not feeling well. And so I had to go in there and chill with her, you know, try to make her feel better. And, you know, that way she ain't laying there sick by herself, you know. She's been under the weather for like the last few days. Dolly, you was a rock star last night. I'm a rock star every day. What are you talking about? You know, when sometimes I'm trying to be serious, right? But I think most people enjoy the Dolly comedy, you know. So I gave y'all a little something last night. No, she's definitely not pregnant. She just don't feel good. She just don't feel good. I think she's allergic to something. I'm not for sure. So she's here this morning, right? She called in out of work because she wasn't feeling well. You know, I told her to get a little extra sleep because PJ gets up really early, and she ain't been feeling good, so she ain't been sleeping well. Yeah, I hope she gets to feeling better too. We'll see how she feels a little later, you know, if the rest helped her. I agree, Butterfly Kisses last night, the best. Yeah, I gave y'all guys a few jokes, a few laughs, you know. I hope y'all enjoyed it. Now, you know, these people that, you know, cover Karen Rea's case, all of them, I could clown them. I look at them like easy work too, right? All right, let's do it. I seen Hank the Tank up there. Court TV's having problems with their feed.
Karen Rea and Judge Cosgrove, special prosecutor Cosgrove.
Come on, Court TV. They do have terrible reception right now.
I have, from the beginning, kept a very line of separation between both Miss Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit and a search warrant, and there are two pleadings as well in my motion that are on the public docket. And so,
oh my God, come on, he wants a search warrant, and it's breaking up.
what I know is that there are two phones that were searched by Trooper DOLLY and is in the possession of the District Attorney's Office, and the information is relevant material to Karen Rea's case. The reason why it's important and relevant is that
God, Court TV, get it together.
to Kearney, but relationship and where information, some of the suggestive grand jury minutes, was passed to Kearney. Originally, a third party was used, an intermediary, where
Court TV will get it together. Give them a second.
Intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware.
All right,
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I would re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports been requested been generated?
I understand they are available to Special Prosecutor Courtroom and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
It's working
No
now.
idea because I've purposely not asked to see it or ask questions about it.
Okay.
Ah. All right, hold on.
As it relates to consciousness of.
Let me go over here to law and crime.
We expect evidence will show separately and in Mr. Kearney's phone is that there was a relationship between Karen Rea and Mr. Kearney in which Ms. Reed would provide information indirectly to Mr. Kearney. That information would then be reviewed by Mr. Kearney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses.
Amen.
Struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make
They just getting there?
that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney is
Look, Karen's look.
I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're.
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannone, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Rea.
00117.
Okay.
That's correct.
Then she needed to be here and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for
This judge is
her
strict.
case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel,
Correct, but we
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or an admissibility standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years.
Yes, that's Turtle Boy.
Over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights. And it's
No,
her
it
case
don't.
number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intend
Tell
to
him,
submit
Judge.
oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Cannone,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current?
Okay, this one is terrible. That feed is terrible. Let's go back to this.
Object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
I can't stand this guy.
So,
Her lawyer is a piece of shit. He's like a
The
crybaby.
court's apologies for the interruptions. The crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana
They're
Albert,
trying to get his phone,
Michael
his
Proctor,
records.
Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Rea case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are
He does look
squarely
sharp. I like
on
his
point
suit.
and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled, because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Rea case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth v. Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history.
I think
and
she's
it gives
guilty.
assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to consciousness of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannone in a motion in limine regarding consciousness of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Good Lord. Good Lord. Do I still have court TV?
Counsel.
Oh,
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Good morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning there has to be evidence As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, oh, well, there was probable cause and a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something, and I was prompted to write this press release that I sent out about this exact issue. And I went back to it. I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aidan Kearney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses.
She is.
So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong. The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Kearney and consciousness of guilt, unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Kearney's phones. We're not concerned about what's in Mr. Kearney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations are don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right when to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Kearney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Give up his phone.
So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Kearney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation, and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special ADA Cosgrove's possession, custody, control. It's already been seized. ADA Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never
Damn.
should have gone
before
through
me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant?
Right. What do they have? What do they have to set that up? They have the fact that they spoke, and the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke
harassing people
was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife
Counsel,
communication.
you're not asking.
No, not you, just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint
He's
team
not a
issues are still in
journalist,
flux.
though.
You know, the fact that they did this, the
Good
court
morning,
should
William.
deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little, Your Honor.
Thank you, Your Honor. Elizabeth Little, hearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradle, apologies, Your Honor.
It's a lot of
There are.
I think it's going to be a
Commonwealth's
conviction.
affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that the grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr.
She most definitely was. She admitted
and
to
on
it last
that
night.
basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional
Go, Hank.
prowess of Mr. Bradle. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless.
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a conscience of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The conscience of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannone if appropriate, and then she should decide the admissibility.
She has four.
Karen Retrial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids are. Yes, exactly. Right. Exactly.
Okay, so they're going to sidebar for a minute.
And seems to encourage it impliedly. And so this evidence should be available to me.
Thank you, Sassy.
Assess it. I should be able to provide a motion to eliminate to Judge Cannone if appropriate, and then she should decide the admissibility in the Commonwealth of Karen Retrial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids are.
Okay, so he ain't going to rule on that right this second, so we're going to wait on the ruling to that. But if they already have the phones, I think he's going to use it against them. So we still got motions for Karen Rea. That was the motion on Turtleboy to see if they could seize Turtleboy's records from his phone and use them against him. And right now, I guess we don't know the outcome of that. I don't think in the case really though it's going to change much. It just shows the mindset of Karen Rea that she was willing to harass these witnesses to cover up her crime. I think that's what Hank the Tank is trying to prove, that she was willing to give up this information. She wanted him to do this, and he did this because she told him to. Of course, they don't want that coming out in the court. And, you know, his lawyer getting up there saying, you know, like, you know, stuff for his journal or his report and shouldn't be released. That's not true because he's not a journalist. He's not. Just because you make a Bullhorn Betty press pass don't make you actual press. What notable press company does he work for? He made up a website and that's it. That's he's media, right? So that's like me walking in there and printing up my own press pass like Bullhorn Betty and making a website and say, well, I got a website. It's the same thing. This dude is no different than Bullhorn Betty with a fake ass press pass. He's not really media. So how they treating this dude like he's media when he's not? Okay, I bet you the people that went to school that are sitting there at Court TV and Law and Crime and all these people that went to school to be journalists are thinking, well, damn, all I needed was a .com. Okay, I have a .com. Does that make me a journalist? If I post a story on my .com, am I all of a sudden a journalist? Why they would even give this dude credentials is beyond me. It's a joke. And you're making the legal system by allowing this into a joke is how I look at it. Like, I guarantee you this. Next time I go to a court case, I'm going to say I'm press. Hey, I wrote a story. I'm going to write a story on my .com and be like, hey, I got a story on my .com. I'm with the media, and let me bring my phone in. Let me bring my computer in. Let me bring all these things in I usually can't bring into the courtroom as just a member of the public. And I write in a journal. I'm a journalist. There you go, right? That's about what it is, right? He has a diary. It makes him a journalist. This is like a slap in the face to the legal system to me. Like, it's almost a joke. There's people, why go to journalism school? Why do people go to college for journalism? If you can just be a journalist by writing in your note on that yellow sheet of paper, right? Because you type into a .com that nobody reads. It's probably read by fucking 500 people, and that's it. Come on, that is a joke. That is a joke. Ain't no serious publication would print none of your shit. Can't believe I went to journalism school. LOL, right? I bet you that's what they're thinking. They spent all this money. They probably owe college debts and everything. And you got this dude that just walks in there talking about, I'm a journalist. I just got here. Who you talking about? Nick the Hat? No, I'm talking about Turtle Boy with his, because they want Turtle Boy's phones, but they're saying, well, there's certain things they can't have because he's a journalist. He is a joke. Okay. Just a joke. Turtle Boy harassed these people and exploited their minor children, caused additional mental anguish to the Okeefe family. He needs to be charged. Well, he has been charged, and his time in court, Rose, is coming. He has to stand trial for those, 16 different harassing of witness charges, right? His lawyer's talking about, well, there's a motion to see if we get this thrown out. A motion don't mean it's going to get thrown out. He says we expect it to get thrown out. Well, you may be wrong. He may go to jail, right? So he has been harassing witnesses. He's not this ain't like he works for CNN, Fox News, any local news company, televised news company, or local paper. He don't work for any of that, right? But yet they're going to treat him like he does. Okay. So when I show up in Boston, I'm showing up with a media pass. I'm showing up as a journalist. I want the same rights as this dude. Let me in the courtroom. I want to bring my phone. I want to bring my computer. All that, because I'm a journalist. And before I go, I'll make sure that my page is up to date with stories and a couple little write-ups that I do on the Karen Rea story. I'm going to be like, hey, go check it out. I'm a journalist. Let me, I want to bring my cell phone in. I want to bring my computers in. You see what they told me in Tennessee, right? They were like, oh, no, only official media can bring their shit in. Now, I could have applied for a media pass there, but I didn't know. And when I went, if I would have applied for it before I went, I most likely would have got it there. And I could have brought all my stuff in. But to me, this is just a joke. You don't need a degree. Most of them have overstepped their boundaries. The degree holder is owned regardless of what it is. Cracks me up. Most journalists lie. Just saying. Well, why even bother going to school? Why, if you don't need, these people spend all this money on an education, and then you got a dude that is like a back alley journalist, basically. And no different than Bullhorn Betty. No different. Bullhorn Betty runs around screaming she's media. And you seen the judge in the Bullhorn Betty case said, oh, you printed this out yourself? You made this? Like, that don't hold no weight. No weight. But, this is a case where there's a lot of money in play. There's a lot of money. These people have, raised, what, $2 million? So this is a case where people are buying shit. Pockets are being filled. You know what I'm saying? And that's when it gets sketchy, because we've seen OJ trial, right? In the OJ trial, he bought his freedom. This is going to be the case. If she walks, this woman's bought her freedom. You know, these judges that are siding with her, that's because they probably go golfing and they hang out. You know what I'm saying? Probably not with Alan Jackson because he's not from there. But Yannetti, you know what I'm saying? The Bradle dude, they've been in law. They've been in that area for a long time. They got friends. All these they go golfing together and shit. It's money to buy your freedom. Good morning, Dolly. PJ chat. How's it going? It's going pretty good, Night Demon. Not too bad. We just covering a little bit of this Karen Rea stuff this morning. So we're just watching the fan until the motions start for Karen Rea. And I don't know where Judge Bev is. Maybe the 17 hearing was because of maybe Judge Bev will be there for the motions for Karen Rea. But that motion was for Turtleboy, and Karen Rea and them wasn't supposed to be there. So maybe Aunt Bev will be there for the actual Karen Rea stuff. Okay. So we're going to see how it plays out today. We'll see. Judge will be there later for Karen, Judge Bev. That's what I'm thinking. We got fires in Texas. Oh, okay. Well, I hope everything goes good. Texas got wildfires, huh? Turtleboy and his humping partner, they are a little close to Karen Rea. Makes you wonder why. I don't know. I mean, to me, I'm surprised he didn't get his bond revoked. You know, but you know, I guess you pay the judges enough to go golf, and they don't put you in jail. I watched his hearing the day before yesterday. He had court the same day as Karen Rea, but in the afternoon. And the prosecution went to strike his bond, and they argued that they said they wasn't going to do that, and now they're trying to do it, and they sided with Turtleboy. Okay, they said it should have been done in the very beginning at his arraignment. So they let him slide and gave him a bond. So he's still walking free to harass. He don't learn his lesson. He's like a little, I don't know, the smirk on his face. Like he acts like he's the shit or something. Like you's a piece of shit to me, you know. I know some people disagree with that. They think, oh, they're fighting for justice for Karen Rea. I just have a different opinion than some of you guys on it. And if she does go to prison, I can't wait to laugh at some of her cult members, right? Just because of how it ain't even that I want her 100% prosecuted. It's because I just can't stand how they act, how shitty of people her supporters are. Some of them, not all of them. I think some of them are good people. Like some of them out there for the right reasons. Like I honestly like Rita. She seemed like she had a little bit of common sense, and she was really out there fighting for Karen Rea. It's just like the rest of them I can't stand. You got the drunk baby Gap. You got creepy old Tom talking about women and their kids. I mean, it's just, and she has a whole bunch of nut riders behind her. A whole bunch of yes people. That I can't stand that stuff. It makes me sick that people would sell their souls for a click and a view. But I guess that's the way of the world here on YouTube, right? I guess if you want thousands of people watching you, you jump on the free Karen Rea train. No, Baby Gap is not JLR. Okay, JLR is nothing like Baby Gap. JLR puts in work. Baby Gap don't really do shit. I take it you don't like him then, Dolly. Who? Turtle? I don't like any of them. I don't like anybody around her. I like her herself better. And I'll give you this. The documentary did this. It does make her look guilty, but it humanizes her a lot, which is going to draw her even more support, right? Because, you know, they're showing her hugging kids and different things. They don't show the stuck-upness that I seen when I was there. They show her in a more loving, caring, humanized way in the documentary, which I think the documentary helps her in that aspect. But far as admitting to her guilt and not giving a damn, it hurts her. right? Because she's adding to it. She, just like last night in the one documentary, she was saying, well, yeah, I communicated with Turtle Boy, and yeah, he was harassing the people, but they shouldn't be witnesses. They should be suspects. But here's the thing. They are witnesses. You can't choose yourself who's a suspect and who's a witness. Baby Gap is cloned to a bottle of whiskey. I mean, that dude right there is a raging alcoholic. Okay, we seen that. You've seen him debate me or try to debate me slam drunk. It didn't end well for him. And any of them can come up here, right? Bring your ass on up here. Tom's scared. I even invited Tom up. He's scared. He knows in a normal conversation, he don't stand a chance. Turtle Boy wouldn't dare be brave enough, right? Because all he does is try to act like he knows everything, just like he's done with other people. JLR is in the bushes looking for his rooster. I don't know. JLR is quick to be everywhere, and he's putting in work. I mean, you can't knock a person that gets out there and works. He works his ass off. He's a little different than, me, of course, but I don't hate on the man. More power to you. He ain't a grind ball like some of these people. I can say that. He's a little unique and a little weird, in his own way, which everybody is, but at least he ain't a shit. I mean, he in his past was bad, but lately what JLR has been doing, I don't really like. It ain't my cup of tea, but I respect it. It's it's nothing bad. He sticks to true crime. He don't do the drama stuff. So I respect his hustle, and his success is because he works so hard. Now, if I worked that hard, I would have the same success, but Dolly's a little lazy. Like I got shit going on. I can't jump on the internet every time something breaks on CNN or Fox News. I mean, that's basically what he does. He waits for it. And then as soon as it hits, boom, he's on the internet. I just don't got time to do that. You know what I'm saying? I don't have time. I'm doing a million other things and the YouTube stuff simultaneously. I don't like him based on the red hat alone. The alarm clock just went off. It's called growth. It's called learning lesson. So I will be up there in Dedham.
Good morning, Dolly. Kissing face emoji.
Hey, Sweet Jones. I think you're the first super chat of the morning. Keeping Dolly alive, $4.99. Thank you so much. That is awesome of you, Sweet Jones. I hope you have a wonderful day today. I think I'm going to sleep most of it because I've been up late as shit, but I slept all day yesterday. So I was like, there's no reason for me to go try to lay down. I slept like 20 hours yesterday. So, but when I crash out here in a little while, it's going to that pillow is going to feel good. My sleep schedule's all jacked up. All right. We back in the courtroom. All right, we're just waiting for it to start now.
Go ahead here, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Rea. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara Boston for the Commonwealth. Good morning, Mr. Boston.
Avalon for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
I like them too.
For Karen.
Little
Good
and the
morning,
other
Mr. Nettie.
dude.
Good morning, Ms. Reed. All right.
I can't stand
So
Alan
we have
Jackson. He's
lot
like a
to
whiny
cover this morning. But what I want to start with,
Uh-oh,
I was just
sitting
handed a couple of things
behind-
too that I'm
behind
going to
Sweet
need some
Jones on
time
the
to
train.
read.
Awesome.
What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
all three indictments, correct? You're
I understand
defending
that,
all 3.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance, and I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns.
No, we got a trip plan.
Different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay.
They're talking
All right,
10
so
weeks
let's
to
go
pick a jury?
the
No
next
way.
motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me?
They're going to do the buffer zone. We know that. They did it last trial.
I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have. I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We've received it.
Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned, based on past reports and information, that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases and other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We'll take that position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read
Put them about a
and
mile
consider,
away.
Today's email from the merchants. Okay.
Yeah, somebody throw up my link to my sweatshirts. You can save 20% when you use the promo code Say No to Drugs.
From the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
Of course.
Okay.
Yes.
All right. Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
The Commonwealth first, Your Honor.
Well, it's defendant's motion. And the Commonwealth opposed it.
You had asked who's arguing that for the Commonwealth. That's why
I'm
I-
sorry,
I-
defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the.
I'm fine with him going first if you'd like.
Okay.
Get him, Hank.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment, at the time they wrote the report, and then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is a undefined relationship between the defense and the United States Attorney's Office.
Thank you,
around
Kimberly.
this investigation.
Welcome to the Dolly
And we
train.
subsequently learned that there was a continued relationship. And so today, as we sit here, we
Thank
really
you,
don't know. What we
Sonia.
know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began
guys are
by
awesome.
asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th? Nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately, there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just asking the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Ron.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about
You paid
who
them.
hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you just said it's late. Hold on. You just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball. when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Rea or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right. So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
Move on.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that we have a jury sitting for weeks at a time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection. And I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Well, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. I think there's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to to change its ruling from the first trial.
Okay, that motion is denied. So the
Denied.
next motion, defendant's motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not,
Okay,
so we can agree to that motion.
all right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror
We're
names
going through
during
stuff
trial.
quick today.
Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number one, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the
Good
court to
morning.
do that.
Any objection from the defense?
Yeah, he went to court.
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion perhaps incorrectly that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like
that-
to
All right,
address.
so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a
change.
new trial, Judge.
Right,
I've
no,
been
so
told.
just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, 1 photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan. Paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for the defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorti-Bello. Oh,
Not on their witness list.
right.
Just number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Vernon did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the registry of motor vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick, so that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer, does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Vernon?
Is it the common practice of this office?
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record and re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, you know, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving
thought-
the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right.
Okay, break time.
You are muted.
I'll be right back. Hold on, guys. Okay, so they're going through the motions pretty quick today. Right now, we're going to court is at is on a short break for, I guess, lunch. I guess they're taking. So, anyway, I've been trying to put a chat box up here where you can see the chat in my room, and for some reason, I cannot get that chat box. See how they're writing down here underneath me beside the desk? It shows what you guys are saying. I cannot get that to go into a chat box. The way it used to work is not working. I've been like, while we've been sitting here watching the trial, I've been trying to figure that out for like the last 30 minutes or so. And it is just not working for me. It's fighting me every bit of the way. So I'm trying these different codes, and it just is not working. So I'm reading all these forms, and I guess a lot of people are having that same problem. All right, here's a form. Let me see what this form says. Same. Okay, so I guess a lot of people are having that problem. And I went to this link. Let's see. Huh. Okay, so apparently YouTube changed something. So you can have the chat on the screen like that. I just can't have it in a box where, you know, it's a little more clear and visible. Okay, that ain't gonna work for me. Let's see if there's anything else that may be able to tell me how to put this damn chat box up there. This is the same thing it's doing to me. My YouTube chat box flickers for a second, and then it disappears. I wonder what they're gonna say to fix it. Okay, still flickers and disappears. That's what mine is doing. Hello, I was having the same issue myself. After trial and error, sadly, the only way to make the chat appear and make it stay is by unchecking all the animation properties on the chat VT style generator. I did that. So you have to create a brand new layout with no animation property, sad to say. Not sure if a coding issue though on the site or some issue related to the browser itself on OBS. I also updated the newest version of OBS 29 and still was having the same issue. Hopefully the new version of the generator may come out so the chat can be animated again. But hopefully this will help until issue is solved. Now I've done that. Hello. I could have swore I'd done that. All right, let me try that again. Copy. Let me go here. I took off all the chat generators, animations. Okay. Let me see. I don't have one animation on. And it still didn't work. Let's see. Background color. Black. Okay, let's try this. Let me try this code. Let me see. Show sponsor fan funding. Blah, blah, blah. All right, let me copy this code real quick, guys. I'm trying to multitask while we're on break. People in the forums are saying this will fix it, but I've tried everything. I'm pretty sure that I've tried this, but I'm going to try it one more time just to. Somebody said it's giving them a headache. I was thinking the same thing. I was like, man, I've been trying to do this for an hour and it's not working. Okay, chat box 2. Browser setting. Okay, I don't see it changing. Yeah, I don't see it working. It should be a black box right here on my screen, but it should pop up, but it's not. So that didn't work. All right, that sucks. Okay, I give up. What stream is Stearns on? Stearns was in court, but it ended now. I didn't even know he was in court today. I was trying to fix my chat box on the screen. I was just working on the layout, but for some reason I cannot get it to work. Like it's just not working at all. Like when the chat pops up, I was trying to get the chat to pop up in a box instead of just popping up on the screen. Like, see, I was just writing on the screen, but it's not in a box or like a little thing, you know. I was trying to fix that, but maybe because you have the overlay for background picture. No, that's not what it is. Because it would be down here. I don't have nothing. That's on top of the picture. So allegedly speculating streamed it. Okay, I didn't even know it was on this morning. So let me see something. Yeah, I might have to re-upload some stuff or let me see if something's on Reddit about it. I don't see nothing. But then again, I don't really know how to work Reddit that good. Okay. Grr. Um. Okay. How to add YouTube chat to OBS step by step. That's old though. Oh well, hell with it. Hell with it. I ain't gonna spend my whole day trying to fix. Your chat box is on the black background. What do you mean it's on the black background? I don't have no black background on my screen. It's supposed to be in a box, and it's not. You know, like I'm talking about the chat that you see on my screen that's popping up down here. Not the YouTube chat box. YouTube chat's working fine. It's the chat box on my screen that I'm trying to change. It is on the black mode. Question mark. I don't get what you're saying. Your chat is showing large on your screen. I know it's showing right here, like right below my left-hand side, right under the Karen Rea picture. But it's supposed to be in a box. And every time I program the box in there, it pops up for a second and then it vanishes. And when I searched it, I guess other people were having that same type of problem with their chat boxes. It looks like a transparent overlay to me on Android tablet. Yes, that's what it looks like for me too. It's not working right because apparently they're saying YouTube changed something and you got to do something to fix it. But I've been trying to fix it and it's not working. No, you're in a box, Dolly, and writing on side can still see you through. However, T-Rev would have been a high chair. LOL. Oh, if you're watching on phone, there may be chat right here, right? That pops up on your phone. We're going to switch the layout because I know it does that. I'm talking about this chat that's right here below me on the screen. That should be in a box, and it's not. Mine froze. I just refreshed. Oh, I don't know if I'm going to make it through all these motions today. I'm getting a little tired. No, you're in a box, Dolly, and your writing is on the outside. Can still see you, though. What are you watching on a phone? Wake up, Dolly. Okay, 'cause I'm not watching on the phone. Let me see what it looks like on the phone. Let me see. Let me see what you guys are seeing. Dolly Vision, Karen Rea.
It's been proven that husky liners with our ProGuard formula
Okay,
are
come on with the
for the leading
commercials.
brand because we believe all feet.
Skip.
It's been proven that husky liners with our
Okay, if you turn it sideways, y'all must be watching it like this. Oh, okay. See, like mine shows up like that, where the chat's in a box, and then I'm on a box on the screen. I only got 418 likes. I'm echoing. Hold on, let me turn that down. Yeah, I gotta fix that. I'll get it fixed. I'll get it figured out. Oh yeah, I'm in. Oh, you can change the mode. Yeah, mine's white on my screen. But like I said, I was trying to fix the layout over here, not the box that YouTube has my chat in. Pop out the box. Hold on. On here on my phone? Let me see. Let's see. Settings. It don't have that setting for me. I can do it on my YouTube, like when I'm on my computer, I can pop the chat out. Oh yeah, on my computer I can pop the chat out. I wasn't looking at it from my computer. Like I said, I was trying to fix that, but I couldn't figure out how to do it. It has to be like an update or something. And then I tried a different layout, like a different animated box, but I'm not sure how that works. Good old retrograde. But I'll get it figured out. You know, I'm a little tired. I'll get a little aggravated for messing with it, and then I'm like over it. I'm like, the hell with this damn thing. I'll fix it later. It's been like this for months. So if it's been like this long, I guess I can live with it. I know how to change the color of everything, right? Like I can change the writing color. Like let me do that real fast. But I cannot put it in a box, which is the weirdest shit to me. Like, okay, what color do we want it? Let's see, text color. I got the text color white right now. Let's do text color green. Maybe that'll stick out. All right. All right, that should be text color. And it says background color. All right, now let's close that. Now, when the text pops back up here, it should be green. Now, I don't know if it's going to be green because it's been acting crazy, but I'm just trying to get it where you can see, like if you was just watching a video, like the replay of the video, and you didn't have the chat pulled up, you could still see the chat on the screen. And then once I get it where it's in a box, I wanted to get it where it came up one comment at a time. Instead of like how you see it rolling, it'd just be one person's comment pop up, then the next person's, it would just keep popping up the next comment instead of rolling through the comments like crazily. So I'll see if I can get that to work, but I ain't got my hopes too high. No, lost chat now, Dolly. Yeah, I know. Nobody puts Dolly in a box, right? It'll come back up. Sometimes it takes a second. Do you want it like Clues? I don't know, how does Clue do hers? Is it in a box? I don't know what she streams on. I'm streaming on Streamlabs. See, there it popped up green. See, I did be able to change the color. All right, I can change the color. I just can't put it in a box. So I got that much of it figured out. Kind of like Clue. I think she slows the chat. Let me look at Clues real quick. I don't know. Let's see, YouTube. Let's go Clue. Let's see how she does hers. I think I spelled her name wrong. There we go. Let's see how her chat looks. Well, she kind of has hers just floating there. Sort of. I mean, what she's did is I think she's streaming through. Yeah, like you see how you can see her chat on the screen? I mean, I just don't know how I mean, I could do it like that. I could make a background for it. I mean, I know how to do that. So, I mean, yeah, I know how she does that. I mean, I could do I know like a black box and then Okay, let me shut that. Yeah, but there's a way to do it without having to manually do it. Like I could put a black box there and then put that in the black box. Like let me see. Watch this. I'll do it like that just to show you. Maybe I've been trying to do it this whole time, like to put a background right there. But I mean, I know how to do it like that, but there's a shortcut to it. Like, hold on. Like, let me see. Search a chat box. Images. Let me see what chat boxes they got. See, I was trying to make it show up like blocks, and I used to be able to do it, but they've changed something on the internet. Like, let's just say I want to put it in a. Okay, let's just say a purple. What color? Pick a color. Let's go with, I don't know, a red box. Okay. Oh, it pulled up red box like the damn like the movie shit. Okay. Here's a red box. We save it. Okay. I know it'll work like this. Hold on. Let me shrink this down a little bit. Now let me go in here, add a source, image, add source, add new source, browse. Let me click the red box. All right. Done. Now you see how we got the big red box on the screen? We'll shrink this red box to the size of the chat.
Before we begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure that I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
Okay, so it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have
See what I mean?
witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
All right, let's share this again.
discovery motion extends beyond Rule 14. And the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias. And I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
Now, please speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
May it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation,
Okay.
what the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof.
Thank you for joining
The Massachusetts law. So I'll start with case of Cannabin, the SJC's decision of 2000. And I am going to provide 4 parts of Cannabin. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit, comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Caravan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area in the Dalbert Lanigan analysis.
Yeah, I'm going to have some stickers made.
So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the decedent. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion, "her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks, and that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006.
I need to fix that.
It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We've basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giulianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giulianelli's methodology or experience. Instead, it appears that Giulianelli designed these experiments on his own without any guidance. Reading down below, quote, Giulianelli's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giulianelli did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. Continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level.
You seen the cheese I bought her? The squeezy
that
cheese?
is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page.
Oh shit, I just stopped it.
10. Let's see what
Leatherface
he did
right
and
there.
how he honored or didn't honor his own standard.
And Art the Clown.
And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about
Thank you so
things
much.
that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C.
What's up, Jamie?
He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that, but the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanets 3 and 4.
Get the soundboard. I hear
Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's
catch me outside. How about that?
Engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer.
Don't be
Then
rude.
He goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Rea stated to her, etc., etc.
You are fake
In other
news.
words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. That's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert.
Yeah, he's born.
He is
doing the exact same.
also, once again, talking about testimony of individual witnesses. So,
Womp womp. I know he's
the evidence is
terribly
consistent
born.
with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the
Cause of death.
he would not be offering the cause of death? I think the spirit of the report is putting all the information together to see his observation.
All right, guys, look, I got to get ready to wrap up
Hard ground and the cause of death are not within his bailiwick.
because I got to go with PJ to the doctor. I told you she's not been feeling well, so she's going to be going to the doctor. So I got to go with her. All right, just in case she takes any medicine, can't drive or anything like that. So I would stay here with you and watch the rest of this, but like I said, boyfriend duties call. So, and I finally got the layout looking right with the box and the chat in it. So, but I'm going to get ready to take off. You guys be good. You know, just go ahead and tune into Court TV, watch the rest of it. And you guys can tell me what happened when I get back, and I'll see you guys. If I don't see, I'll see you late tonight because we're probably going to be there a while. It shit takes forever. You know how it is at the doctor. Oh, I got Turtle Island tonight. So I will see you guys at 10 o'clock tonight. Okay. And we still have Turtle Island t-shirts. We also got, Elevated Truth officials Turtle Island t-shirt. We got Cluminati's official Turtle Island t-shirt. We got Dumpling, and we got Bombshell Reloaded t-shirts from all them people are on our merch store. So check it out. Grab you a t-shirt while supplies last. We don't have many of them. We have like a few left for Clue. We have a few left for Elevated Truth, few for Dumpling, and a few Turtle Island shirts left. So while supplies last, them shirts are available. Make sure you check them out. BuyDollySoap.com, all that good stuff, blah, 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 blah. And I'll see you guys tonight for Turtle Island. All right. And remember, if nobody else loves you, Dolly does. Peace.